Okay, we'll call the meeting to order. Mike, any seating changes? I think we're,
Representative Short could sit for. I'm sorry, Representative Short could sit for whoever you like.
for Hatch.
Okay.
Okay. Have a motion on the minutes.
Second.
Motion by McGuire, second by Schmidt. Any additions, deletions, or corrections to the minutes? Seeing none, all in favor?
Aye.
Any opposed? Any items to be removed from the consent agenda? Seeing none, need a motion on the consent agenda.
Move to approve.
Motion by Schmidt, second by Burstein. All in favor?
Aye.
Any opposed? Motion carries. Need a-
Mr. Chairman, would you like me to read off the postponement?
Yeah, we need a motion to postpone items.
8A and 9.
Yes, those are the items. I would note that for 9, both 9A and 9B, Gelcar will need a waiver because their deadline to respond is before the July meeting.
There's also, excuse me, the 9A and B as well. Oh, is that what they said? I missed that. Thank you.
Okay. Motion by McGuire to postpone items
8A and 9A and B, and a request a waiver on 9A and B.
second by Burstein. Any discussion? All those in favor?
Aye.
Opposed? Department of Health and Human Services.
All right, this is your objection response to DHHS's in-home supports rule. I've reviewed the department's objection response and you have my comments already. Our office received written testimony for this objection response yesterday, and I reviewed that testimony, and I think it's important to point out that the written testimony conflates the Medicaid state plan with the IHS waiver, and in doing so, the testimony confuses the requirements needed to comply with the federal law. After my review, I do not believe that there are any further bases for objection on the department's objection response.
Move to approve.
Motion by McGuire, second by Gray. Any discussion? Senator Whitley.
Would it be possible to hear, I know we did receive some testimony, would it be possible to hear from those folks who are here today?
For what purpose?
To inform the committee on those remaining concerns?
Yeah. We normally follow the advice of the staff.
And it is the decision of the chair whether he wants to hear oral testimony at this stage.
Not today.
They're here.
We have a motion and a second.
Mr. Chair, particularly because this committee did object to the rules before, I think it would be helpful to hear from the public on this issue.
Okay, who's here from the department to reiterate?
Good morning, Mr. Chairman. Melissa Nemeth, attorney for the Department of Health and Human Services.
Okay.
Happy to, I don't know if you want me to address what was in writing or what the committee would like for testimony from the department at this point.
Senator Whitley.
Thank you. I think, so we have the what was provided by the department, but I understand there are members of the public who wanted to provide input on that. So that maybe we could start with that and then the department could respond.
your response?
The department agrees with the testimony that, or the staff attorney's comments, and can address the written testimony if necessary, but do not feel that it changes substantively in any way the department's previous response to this matter.
Do you have a particular question?
No, I would like to hear from the member of the public, and then the department could respond to that. It's particularly because this committee did have so many, objected to it. I feel like we need to have a broader discussion. So I know there are members of the public who want to provide additional input, and I think we should give them the opportunity to do so.
And to what end? Just to hear, we don't do
inform
this
the
just to
committee.
hear people talk,
I understand that.
so.
I understand.
Right. Who is here that wants to speak again about the same thing that we already objected to? I don't. Yeah, okay, Carolyn.
Thank you, Mr. Chairman. I greatly appreciate your valuable time here today. The case management issue that I raised previously has been resolved in that the department has admitted in writing that the service coordination we are talking about in this rule is case management. And even though it is not identified as such in the rule, they are bound by the federal statutes that govern case management. My second issue is the telehealth, and we don't call it telehealth in this rule. The legislature, both houses, have gone through considerable effort to regulate telehealth. Calling it remote services in this rule serves only to circumvent that guidance that is in statute. I think it's great that the attorneys are now going to, the JELCAR attorneys are now going to opine on the rules before this committee at length. I would caution you, however, that they are not subject experts. The waiver that was read has many subject experts available. I don't believe they were contacted, and more importantly, nor were the providers that this rule will govern and the citizens that will be impacted by it. So to rely solely on the department's testimony and information, I believe, is misguided with the underlying principles that the committee is charged with enforcing. This is a short step to going back to the days of, dark rooms and suitcases of cash. And I'll leave it at that.
I think it's important to explain the purpose of committee staff. We are not subject experts. That is correct. Our job is to inform the committee if there are possible bases of objection based on whether or not the rule complies with federal and state statute. And that is what I did. I did review the waiver and all of the testimony, and I do not see a basis for objection based on the rule not complying with federal statute or the waiver, because the rule does comply with federal statute and the waiver as I have seen it. If you can point out a point in which it doesn't comply with the federal statute and the waiver, then I will absolutely take that into consideration. But I have not, after my lengthy review, found any point in which this rule does not comply with the federal law and the waiver.
Mr. Chairman, committee staff's job to seek out public testimony on rules.
Right.
Under the
That's
statute.
my question for the witness is your claim there was no public hearing?
No, sir, I was at the public hearing. May I respond to the question that was asked to the witness?
Mr. Chair,
Senator Gray?
it seems that right now we're in a back and forth between a
Yeah, that's why I
witness
didn't want to
and the
start this.
department,
Right.
and I don't think that that's productive.
Thank you, Mr. Chair. Thank you for taking my question. So I'm sure you're well aware that GELCAR, can only object to the rules based on the statutory, those statutory reasons under 541A. So do you believe that there is a basis for objection at this point? And if so, what is that one?
I believe that there is a basis for objection in that the remote services, which are telehealth, do not reference the telehealth statutes. So the rule is not consistent with statute. Additionally, in the waiver, the services that the rule is being written about is referred to as telehealth in the waiver. And I've provided those references in my testimony of a couple of days ago that I submitted in writing. I would be very interested to learn why environmental modifications, vehicle modifications, and emergency response buttons are going to be utilized in hospitals by children.
The department may be able to answer that question better. After my review, I believe that the waiver does not restrict the department from using the term remote versus telehealth. The telehealth statutes apply to specific providers, and those providers are not the same as the ones that are providing services under the IHS waiver. So they're two separate things.
Representative McGuire.
Yes, if the remote services included something that would qualify as telehealth, would that be covered by the statutes that we already have?
Yes, especially if those were the providers under that statute.
Thank you.
Senator Whitley, are you satisfied at this point? Thank you. Looking for a motion.
Sir, you have a motion by McGuire, a second by Gray. I believe it was a move to approve.
Okay. You've heard the motion. Any discussion by the committee?
Yeah, if possible, I would love to hear the department respond to the issues raised by the witness.
Thank you for allowing me to speak today. I appreciate the opportunity.
Department.
Good morning. Again, for the record, my name is Melissa Nemeth. I am an attorney for the Bureau of Developmental Services. And to speak to the point of the remote services, the reason that as Attorney Muniz pointed out, the statute that is referenced in the testimony does not apply to the providers in the waiver. That is for providers of Medicaid state plan services. And we are talking about a Medicaid waiver, so it cannot be the same services that are on the state plan. Otherwise, we wouldn't need a waiver. And the providers, additionally, the providers under the in-home support waiver are not regulated by that same statute. So they do not need to comply with the telehealth components there. I would also point out that in the rule, in the section, it's 524.16 that lays out these services. It does lay out all of the parameters that would be necessary for this service, for the identified services to be provided in the remote modality, including it has to be deemed appropriate for that individual. It has to be in their service plan. There has to be oversight. So all of those elements remain, but the fact is that the statute that has been referenced does not apply. In the waiver agreement with CMS, it is not identified that that statute applies. It's laid out in the waiver what all of the qualifications are and how that will be provided. And that's totally permissible by CMS standards. And to address the point of certain services that were asked about in acute care hospitals, the purpose for that, for example, environmental modifications, it wouldn't be that the room in the hospital is being modified, but if the individual is in the hospital and needs modifications to their home prior to being discharged, while they are in the hospital, this allows that service to be provided and billed rather than waiting for the individual to go back to their home to let that service be billed. And the personal emergency response services, that can include something that, for example, has an app on a phone or has an other monthly charge, and the waiver provides that while someone that we will pay that the waiver will pay for that monthly maintenance fee. So if someone went into the hospital and this service was not allowed to be provided in the hospital, they would lose that maintenance of that service that's important to them for that time period. With that, I'm also happy to take any questions from the committee.
Any other questions from the committee? You've heard the motion and the second. In the extended discussion, all those in favor? Aye. Any opposed? One. Okay. So we have a no from Senator Whitley and Representative Schuett. And are you here for criminal records? And thank you.
Okay, yes, sir. This proposal makes changes to no longer allow license-exempt child care providers to receive reimbursement prior to the results of their staff members' criminal records check in order to be in compliance with federal law. And it requires that facilities ensure that these staff members are also supervised during that time. In its request for a fiscal impact statement to the LBA, the department didn't talk about any potential cost to the providers for these new requirements. However, it does sound like the providers can be reimbursed retroactively if that staff member's background check comes back clean. The department asked the LBA for a revised FIS since it did need to cure this defect in the FIS. And since an amended FIS can only be sought in the case where changes are resulting as a result of notice and hearing, they couldn't really get an amended FIS, so they've gotten a revised FIS. But that's actually not a type of FIS that can be sought underneath 541A. So that's the remaining issue, and the committee may need to consider amending 541A to allow getting a FIS in the case of a defect in the initial FIS. But you may have questions for the agency about this.
Good morning. My name is Nicole Burke. I'm the Administrative Rules Coordinator for the Rules Unit at Department of Health and Human Services. I'm happy to answer any questions if you have any.
Do you have a response?
So initially the request for FIS was drafted. It's actually most likely a revenue neutral situation. However, reflecting upon there could be an extra staff person in a facility-based program. Most likely they're just in two people together in one room versus two separate rooms. However, due to it being potentially indeterminable, we did revisit that, submitted it to the LBA, could not do an amended FIS per Attorney Reeves' statements. and have completed what LBA referred to as a revised FIS, and did submit that with our conditional approval.
And I should state that the LBA did identify that the costs were indeterminable.
Okay. Questions from the committee? Motion?
Move to approve.
Second.
Motion by McGuire, second by Lang. Any further discussion from the committee? Peter?
Thank you, Mr. Chairman. Well, it was referenced that the committee might want to consider amending 541A, and I think we ought to at least have a word about that.
It's in process now.
Yeah, it's on.
It is.
Not something we can do.
Well, it's, I understand there's nothing we can do about it at this point. The question is whether the amendment is in works, and I've just heard it is.
Yes, it's, we have a list of 541A amendments that we're working on that you'll see in probably the next couple months.
Terrific, thank you.
Okay,
Mr. Chair?
yes.
Yeah, I'd like to express my concern that we're getting creeping cost growth to our businesses by federal regulations. And therefore, I object to that principle. Even if this specific rule doesn't cause a major impact, it's still a new cost to our businesses that the federal government is imposing on them, and I'm opposed to that idea.
Your comments are noted. Seeing no further questions, we have a motion and a second. All those in favor?
Aye.
Any opposed?
The next rule is 2021-126. It's on home visiting for prenatal, child, and family support services. This was actually, I have no comment on the rule text. This is consent in terms of the rule text. It is on your agenda, however, because if you open up the rule and scroll past the notice, you'll see the fiscal impact statement, and there is a rather significant fiscal impact. It does appear that fiscal impact is due to the statute change. The cost essentially per unit has not changed. It's just the people that would be eligible and the amount of time they would be eligible for has changed. But since it is a rather significant impact, we thought you may have questions for the department.
Again, for the record, my name is Nicole Burke, Administrative Rules Coordinator for the Rules Unit at Department of Health and Human Services. And again, here to answer any specific questions you may have. And with me is the attorney for the unit.
Questions? Motion?
Move to approve.
Motion by Lang, second by Gray. Discussion? Seeing none, all those in favor?
Aye.
Any objectors? Opioid Abatement Trust Fund and Advisory Commission.
Okay, yes, sir. This proposal will adopt rules basically to set up an RFP process for the distributions out of this trust fund account. The agency has filed an amended conditional approval request after our discussions with them this Monday around the need to have some broad scoring criteria in the rule for scoring these RFP applications. There's just one issue remaining, and that is on the first page of the rule, and that is that the originating statute was effective in 2020. And so the committee may have some questions about the delay in bringing forward of these rules.
Good morning, Allison Zinno, Administrator of the Administrative Rules Unit for the Department of Health and Human Services. RSA 126A 83 through 86 became effective 7/1/2020. At that time, the Department of Justice had to form the commission to start working on these rules, which in turn, a work group was formed between DOJ and the department, where they started drafting, crafting, and editing these rules, and met multiple times, and really just have kept going the best we could, also while in the middle of the pandemic.
Representative McGuire.
Thank you, Mr. Chair. Have any grants been awarded?
I can have Attorney Maria Reinman, if she'd like to come and answer that question. She would know
She's
more.
shaking her head, so I presume that means no.
Okay. So no.
Thank you.
Thank you.
Mr. Chair.
Yes.
So question, Senate Bill 275 passed, which deals with this fund as well, and the commission. And my question is, do these rules, or are they in any way in conflict with the current law that was signed by the governor just recently? So Senate Bill 275 passed the House, passed the Senate, was signed by the governor just recently regarding this exact topic, the fund and the commission. My question is, are the changes in that bill, or now law, in conflict in any way with the current rule you're putting forward?
I've also been heading up the opioid litigation. I don't think that the change in that statute will conflict with these rules. The changes were fairly minor to change the census numbers. The original legislation had the 2010 census numbers for distribution to those 23 subdivisions who had filed lawsuits. So it changes it so that we'd use the most current census figures. It also adds a member to the commission, and expands very slightly the types of approved uses for opioid abatement funds that can be authorized under the statute. So I don't think that it changes that in any significant way.
Thank you.
Thank you.
Move to approve.
Motion by Lang, second by Burstein. Discussion? All those in favor?
Aye.
Any opposed? Sanitary production and distribution of food.
Yes, thank you. My name is Attorney Rebecca Ricard. I'm the newest attorney here with the Joint Staff Committee.
Excuse my omission here, but let me introduce Rebecca Ricard to everyone present.
My
and-
apologies. I should have done that at the start of the
Welcome her to Gelcar and to.
Yes. Thank you very much. And I apologize. This is my first meeting, so I should have brought this to the committee's attention initially. We are asking that this one be postponed as well. The agency did submit a conditional approval that did address a number of the staff's comments, but there were still a couple that need to be worked on. So the agency has requested that this be postponed to the next meeting in order to file an amended conditional approval to address those additional
Motion.
comments.
Second.
Motion by Schmidt, second by Lang. Any discussion? All those in favor?
Aye.
Any opposed? All right.
Right, the next rule is 2022-18 of the Insurance Department. This rule is based on the NAIC model, so it's going to look a little different than some, rules you normally see. That is a statutory exemption in 541A. My only comment is on page 44 of the rules. It appears to the conflicts with other laws section of the rule. The department may have a lack of authority here because it appears that the rule is allowing the rule to supersede state statute. I also want to note, though, this is the exact same language that came through in 2012, and we did not have a comment on it then. So this This has been the rule, I think, for 10 years now. But yeah, you may have questions. I think the department may be able to explain better.
And is Commissioner Nicolopoulos here? Okay.
How about now?
There you go.
There we go. Okay. Good morning. Yes. So, yeah. So, my name is Heather Silverstein. I'm General Counsel for the Insurance Department. This rule is based off a model regulation. It's a long-term care regulation from the National Association of Insurance Commissioners, with the NEIC. And the reason that the regulation is written in this way and that we also write our regulation this way is because long-term care products, insurance products, are different than major medical insurance products. And so all this rule is stating is that the statutes and rules that apply to major medical products do not apply to this particular long-term care product, and how they review benefit determination. So let's say a company denied the benefit. There's a procedure that you can appeal internally and externally related to those decisions. And for long-term care, it's related to 415D, which are statute, and this rule 3601. Now, if you were in major med, the way that you would appeal would be through the external review process, which is a different rule, INS 2700. So that's all this rule does, is it's just saying these statutes and rules that wouldn't apply, they don't apply.
Yes.
In that case, I think that you should more clearly reword that section so that instead of saying the provisions of this section supersede the statutes, the statutes do not apply, which, if you're correct, is a more appropriate way to say it. You can't override a statute in a rule.
True. And like I said, we just follow the model language. And so that's all. It's just saying, it's clarifying that we're not in a major med product, so we don't apply those rules.
Fine.
Yeah.
I'd like to move to make a conditional approval request.
Second.
Would you prefer the sentence be changed around so it has, RSA 420 in the citations do not apply to
Yes.
this rule?
You can't say in a rule that you're superseding a statute. You can say that the statute does not apply, which I would agree with, but you can't say you're superseding it.
Would that work for the department?
The only thing that I would just have concerns about is the change in the statutes. We're just trying to, I want to make sure that it's clear that that the provisions for review are in INS 3601, and that practitioners and other people looking at the rule would understand that these major medical statutes and rules do not apply. So that's my concern. I guess I would have to look at how you wanted to word it.
If you would say that they do not apply, I think that should be clear enough.
Yeah, I think do not apply, I would feel more comfortable with if you wanted to do it that way.
I do.
So I'm just going to read this whole sentence. So it would read RSA 420J 5A, RSA 420J 5B, RSA 420J 5C, and INS 2703 do not apply for external review requirements to these rules?
Yes.
But it's not to the
Shall
rules.
not apply.
Shall not apply.
Shall not.
To this to a long-term care insurance policy is what it really is.
Right, those are statutes that are not, though, like I said, they're
Do not
separate
apply
statute.
to long-term care. Which is what the rule is about.
Senator Gray.
That was what I was going to say, is that
Thank you.
that provision should be added in there, that they don't apply to long care. And that makes it clear, which is what the attorney said at the beginning of her testimony.
So you could read it back to me.
sorry, it would be RSA 420J5A, RSA 420J5B, RSA 420J5C, and INS 2703 shall not apply for the purposes of external review requirements for long-term care insurance.
Yes. And that would be what would exist in this particular provision in I, under conflict with other laws. Yes. That would replace it. That's what you're saying.
Right.
Yes.
Yes, do not.
Representative Schmidt.
There's a question whether
Unfortunately,
it
if
should
we
be
say
do not
do-
apply or shall not apply. You think shall?
If we say do not apply, you no longer have a rule. There is no requirement in place. So it needs to say shall not apply or shall not be applicable.
Shall not be applicable.
That's why we have lawyers.
Thank you.
Motion is for conditional approval. All those in favor?
Aye.
Any object?
And I'll send the department a letter with all of that written out so you can see it. before.
Great, thank you.
Department of Safety.
Mr. Chairman, we also have an emergency rule from the Pharmacy Board, item 8B.
Okay. Let's do this. Let the safety people get
Okay.
out of here.
This is an emergency rule put forward by the Pharmacy Board. As some of you may have read in the news, there's a severe shortage worldwide for contrast media for CT scans. The medical, the medicine that's used to intravenously to create a contrast so the CT will work is in very short supply. What the Pharmacy Board would like to do in these rules is to allow for single dose vials to be used for more than one patient, because there's more medicine in the vial than is necessary for a single patient. This way they can use that towards a second patient and eventually lower the amount, to give more people this medication. That's it.
Okay, that's an emergency rule.
And there does seem to be a basis for the emergency.
Good luck.
Thank you.
Well done, Tina.
Now Department of Safety.
Okay, yes, sir. This proposal makes changes to the rules governing the installation and use of ignition interlock devices. The agency has late filed a conditional approval request, and so first the committee needs to vote to accept that before we can discuss the issues that remain.
So move.
Motion
Second.
by Gray, second by Lang. All those in favor?
Aye.
Any opposed?
Okay, so there are 5 items to bring to your attention. The first one is on page 2 at the bottom of the page. Here the rule says that the form can be found on the referenced website, but it's not there yet. In discussion with the department states that the form will be posted after GELCAR approval. The next item is on page 6, and there's a similar comment also on page 7. So here the rule requires that the device be set at 0.020. Testimony has been submitted stating that this is a violation of legislative intent because RSA 265A 37 Roman 3A. But that statute actually says that there will be penalties for a person if their breath alcohol concentration is over 0.025. It doesn't require that the device be set at 0.025. So it would seem to be a policy decision whether or not to set that device lower, since I didn't find anything in the statute that would affirmatively require it to be set at a specific, level. So you may have some questions for the department about that. or I can move on to the next point.
Well, you should be there already.
All right, thank you. My name's Marta Motiani. I'm representing the Department of Safety. I'm an attorney in the legal unit, and the rulemaking allows the commissioner to set forth the model, the specifications for the devices, and in the rules, the department has incorporated by reference the NHTSA model specs for the device, which sets forth a alcohol set point of 0.020 for, and that does not ring up the user as a violation, but it just stops the vehicle from starting. So the alcohol set point is 0.020, but the violation set point is 0.025. So if they blow in the device and it reads 0.025 or more, the user has failed and violated the program.
What happens if they blow up 0.21?
It records and it sends that data, and it just stops the vehicle from running until they're able to.
That sounds like a penalty to me.
It's not a penalty, it just doesn't start the car. It tells the person who they shouldn't be driving at that point. Until it's dissipated.
Next.
Okay, so the next comment is on page 9, and we received testimony suggesting that the rule language should be amended, and it says that the device, because it was a little confusing, but I think that the testimony seemed to be saying that at this point in time, the device would already be installed. However, this section is about initial installation of the device. So in looking at that testimony, it didn't seem that the changes that were suggested would be appropriate, since the device, this is about initial installation of the device. I didn't know if you had any comments, or any questions for the department about that, but it really did seem like that this whole section is about initial installation.
It is about the initial installation, and it is in order to ensure that the person who is having the device installed has demonstrated proficiency by blowing 3 times and passing before they get the certificate.
Yes, thank you. I agree that the sequence seems wrong, that this is obviously the checkout after the device is installed and you're demonstrating this proficiency, which is fine, but does this mean that the interlock service provider will then immediately remove the device if they fail the test, if they can't blow 3 times?
They shouldn't, if they can't pass it, yes, I believe that's the case. But I've got the DMV here.
We want to understand.
This is Bob Keller, who's currently the acting administrator of the Bureau of Financial Responsibility, and the the deputy director of the DMV, Mike Todd.
So at the initial installation, the initial installation, that we're looking for that proficiency. Nothing states that it needs to be installed in their vehicle at that time to pass those tests. We're just saying that we want to show them proficiency. So I know the providers do have some test models and other devices that they can use to have the operator demonstrate that proficiency, so that they can show that they can safely operate the vehicle before they leave that appointment, that garage.
So this is this is a test of the equipment.
No, it's a test of the person.
Okay.
Right, to ensure the operator knows how to use the device and be able to operate the vehicle.
Okay.
Okay, so the next issue is on page 11, and here the rule says that a person's driving privileges can be suspended when there's a consistent pattern of failures to pass a breath test. And you'll see my comment, I'm agreeing initially with the testimony that was submitted that perhaps the rule needed to have a bit more firm language. But after talking with a staff from the department, I think it probably should stay as it is because it was explained that this language is meant to capture a pattern of behavior. So say if a person can't pass a breath test every Friday night, then that would be a pattern that the hearing officer would need to know about and would be a pattern that that they would need to take in consideration for violations. But I'm sure that the department can explain exactly what is contemplated by that language.
Thank you. SAFC 6512 sets forth the violations, whether a person who has violated the laws, the rules, would incur an extension of the ignition interlock device or a actual suspension of the driver's license. And it also escalates in terms of the number of violations that they have, increases the extension and or the penalties. This rule, that rule already addresses the failures of the breath test, whether it's 1 or 2. This talks about the actual pattern, and that is taken straight from the statute, 265A 38, Roman numeral 2, talks about being able to bring someone in for a hearing for showing a consistent pattern. And I think that in speaking, and I don't want to speak for Mr. Blaisdell here, but in speaking, I think there was some concern that this was about the vendors as opposed to the user. This is a requirement on the user.
Okay, what else do you have?
Okay, so finally on page 16, there's a note, just an informational note regarding the use of the rule citing to RSA 541 rather than 541A for appeals. And normally individuals must avail themselves of the appeal process in 541A unless the statute specifically states otherwise. And in this case, the safety statute does state otherwise. So that is the reason for that citation.
Okay, so we have testimony from Consumer Safety Technology. And you
Good
say
morning.
you support the bill with changes.
Correct. Good morning, Mr. Chairman, members of the committee. For the record, my name is Robert Blaisdell, and I represent Consumer Safety Technology out of Des Moines, Iowa. They are one of the registered vendors with the state for the ignition interlock. By way of background, I've been involved with this issue since the early 2000s. I've been a part of every single legislative hearing as these statutes have been changed over the years. I have pretty good idea what the legislative intent has been. And after talking with the department earlier this morning, I'm going to just focus on just one section of our comments. I believe my first section and my third section, we've essentially worked out, which is going to be fine with a much better understanding. And I appreciate that conversation. So I'm going to focus this morning just on page 9 that I'm aware of, fixed dated text of May 26th, 2022, and it's SAFC 6507.01. We believe that this proposed language in rule creates an additional condition beyond legislative intent. We believe that in RSA 265A:36, Roman numeral 1 and Roman numeral 1A, it clearly states the legislative intent is that this device shall be installed. This creates sort of a putting on the brakes of, wait a minute, no, it's not going to be installed if they can't happen to pass 3 breath tests. Couple of things. We believe that goes beyond the legislative intent, clearly stating that it shall be installed. And secondly, some people can be very savvy, and if they don't like the fact that this device is being mandated upon them to install in any registered vehicle that they have, they can simply go in and not pass the 3 tests. And guess what happens? That device, as it says, no interlock service provider shall install a device in a vehicle of a user who is unable to pass the breath test. They're walking away that day with no ignition interlock on their car or cars. And we don't believe that's in the public interest, because this person has been deemed a concern of public safety, and this device shall be installed. So again, we just believe that this is a needless loophole. I believe it's unintentional, and we have concerns about that going beyond legislative intent. And I'll be happy to answer any questions.
Mayor.
Thank you, Mr. Chairman. So you indicated in your initial remarks that you had some conversations, I believe, this morning, and you worked out some of the issues. And did you discuss this particular aspect as well?
We did.
And what is the result of that colloquy?
The result of that, Representative, is that we agreed to disagree very respectfully. It was a wonderful conversation. We just happened to not.
Happy for both of you. But where are we going to go from here is the question.
Well, my understanding is that it's up to you all to determine if this goes beyond the legislative intent about creating an additional condition. Clearly, I think that the statute states that it shall be installed, period. That's what you all as a legislature has determined. These rules are saying, wait a minute, no, it's not going to be installed if they can't do.
Right, I take your point, and I understand, and now we have to hear from our attorneys what they think. Thank you.
Thank you.
So I'm looking at 265A:36, the 2 sections that he's referenced. It said any person who is convicted of driving while under suspension or revocation resulting from a DWI offense shall be required by the court to install an ignition interlock device in any vehicle registered to that person or used by that person on a regular basis. So it does say that it shall be installed. I do take his point that this could create a situation in which the device isn't going to be installed at that time. I don't know whether or not, and maybe the department can speak to it, whether or not it would be installed at a later time, or if there's any provision if a person continuously, blows too high of an alcohol concentration and can't have the device installed. Don't know what happens at that point. So perhaps the committee may need to have those questions answered.
Mike.
Mr. Chairman, committee members, it would seem, I understand the legislative intent is to have the device installed. I would think that with that intent is that the device actually work for the person that's required to use it.
Go ahead.
I would think the intent is that someone who can't safely blow less than 0.2 or 0.25 not be driving. And so the point is to have the ignition interlock device installed so that that person can't drive. Whether or not they can manage the technicality of doing it once doesn't exempt them from, not wanting to have, a car they can drive without showing that they're not drunk.
May I, Mr. Chairman? This isn't about, it's been a little misunderstanding here. This isn't about whether or not this individual passes meaning whether or not their car is going to start or not. This is simply about instructing the individual. I mean, hopefully they're going to show up and they haven't been drinking. This is about the individual having 3 successful tests of they can do it. It's a device that has a little tube that you blow into. And it can get a little bit of, it's not rocket science. It's very simple. You blow into it, but it's obviously different for those who have never done it before. So they just blow into it, and the guts of the device has to determine the breath sample about whether or not there's any alcohol detected or not. So this is not about determining if the car is going to start, and this is about whether, like, training the person. This is what you do. This is how it's done.
Yeah, if I could, so it seems like the issue would be on the language where it says no interlock service provider shall install a device in a vehicle of a user who is unable to pass the breath test. But I mean, at that point, if they're there and they're getting it installed and they can't pass the breath test, I mean, they can't drive, right? So I'm not really sure, and I don't know anything about the legislative intent. I haven't been involved, in those bills, but it would seem to be that, like Mike said, part of the intent would not be for this person to be able to drive even after installation.
Yeah, this is a conundrum. Go ahead, Sue.
Yes.
Yeah.
May I say what happens?
You got to use your mic.
Thank you, Representative Switch. So they show up, they can't pass this test, so the device can't be placed in the vehicle. So what happens at that moment? Is law enforcement called? Do they drive away? Like, what do we do? Because I think the point is to have, in the best case scenario, them show up, taking this seriously, passing this test, putting this device in, and then following along the law so that they're not driving while intoxicated. But if they can't get past that point, what do we do? Because that seems to be the issue. All right. What do we do?
Okay, so first of all, the department may have a different answer than me, but I am not aware of anybody that's not able to use the device. This is a very simple thing where you just blow into a tube. So if our whole concern is the potential savvy person who purposely does not want to pass this test, who doesn't want this device on their vehicle. That's the issue that's created beyond the legislative intent. So to answer your question, what happens currently right now, my understanding is that these people are instructed on how to use the device, and they go off on their way. I have not heard of anybody that has not been able to perform this simple breath test.
Okay.
Department.
Yeah, department, thank you.
Thank you.
Thank you. So one of the things that I'm not going to take it in exact order, so I think I'm going to try to respond in total here, but 265A36(1) was cited, but the second part of that paragraph also says that a certificate proving installation of the device shall be provided to the DMV as a condition precedent to reinstatement of the individual's license to drive. So they shouldn't even be driving. They wouldn't have their suspension lifted in order to drive until we got that certificate of installation. Right. And so
They have to have it on their car, otherwise the car can't operate and they can't drive. That's the idea. It has to be foolproof. I get it that they have to be instructed. It's a simple procedure. I've had it explained several times. And it's a simple procedure, and the device is on there. Car can't be driven without the device having given the go sign.
People could be using someone else's vehicle. Whatever car that they regularly would use is the vehicle that has to have that installation, that device. In addition, I think the DMV would say is that there have been instances in which individuals might say that they were not instructed properly on how to use a device, and that's why there's a failure of sorts when they're brought in, because once that device is put in, if they somehow fail, they are rung up. And so that is to ensure that the individual knows how to, and we know that they know how because they've had 3 past breath tests.
Right, but it's not only the case, as I understand it, that they get rung up, as you say, but the vehicle won't operate. You cannot drive the vehicle. It won't start.
Correct, at .020.
Mr. Chair.
Tim?
Thank you. So I think it's pretty clear. You got to get the device installed first before you get your suspension lifted. Then you get your suspension lifted. Then you have to use the device in order to drive every single time. I don't have an issue with that process. It seems to work clear. My issue is the .20, because the statute specifically says 2.5 is where penalties start occurring.
Correct.
And so yet to Representative McGuire's statute, we're imposing a penalty at a lower rate by saying you can't drive your car at 2.0, which isn't what the statute says. So that's my only concern, is the set point of the alcohol content at 2.0, which is below the statutory. As I look at 265A37, it talks about penalties, and it talks about concentration points of 0.25, 0.25, 0.25, 0.25 throughout the entire thing. And yet somehow now we've set a new standard of 0.20 and said you can't drive at 0.20. So, and somehow the agency thinks it has the authority to do that. That's my only concern.
So the violation set point is when somebody is rung up in terms of being brought in for a hearing, having an extension of the order itself. 0.020 is the alcohol set point, that when the device reads that a 0.020, the vehicle won't start. It's in the person will not be considered having violated. It's just a preventing the car from starting until the alcohol level is lower. That is the model recommendations from the feds. It is the industry standard that was that we've been advised by the other vendors as well. What 265A37 talks about is the violation set point.
Senator Gray?
I agree with the people who are suggesting that we need to go back and have a legislative solution to the 0.020 and 0.025. Right now, I don't believe that the statute, supports what you're doing, taking away the access to the vehicle at that point. And I'll be voting that way unless the provision is changed.
Go ahead, Noam.
Thank you, Mr. Chair. Is it not true that the person is under suspension and is not supposed to drive their vehicle until the device is installed? Therefore, the point up to the level of a violation, the only penalty is that they cannot drive, and they're under suspension anyway, correct?
I think what you're asking is, unless they have the device installed, their license would be suspended. And once they have the DMV has the certificate of installation of that device, they would be able to operate as long as they were in compliance with the program.
Mr. Chair, again, just to clarify, if I heard that right, was again, their license, once they've gotten the device installed in their car, their license status is no longer suspended or revoked. Their license status is valid at that point. The only condition and term is that they have to breathe into the breathalyzer before the car will start. Is that accurate?
they have to comply with the program.
Which is have an interlock device installed and then prior to
Mhm.
starting the car, blow into the breath tube to
Mhm.
make sure. So just as a background, I'm a former police officer. I'm probably the only person here who was certified as a breathalyzer operator. So I understand the process and understand the interlock system. But again, my concern to Senator Gray is that the department's setting a standard that's, I'll say, greater than what's allowed by statute. In other words, they're adding conditions that aren't allowed, as far as I can see, by statute anywhere. You're allowed to create a program, and I understand your difference is that you don't think that not starting the car is a penalty, but I would say that starting the car is not being able to get to where you need to go would be a penalty or a problem for a citizen, and where the state's imposing that problem, and because of a standard that isn't set in statute.
So if I could respond, the department is provided the rulemaking authority to approve the ignition interlock devices, and we've incorporated by reference the Federal Register standard for the model specifications for these devices, which has an alcohol set point of 0.020. This was also, I believe, the recommendations of some of the public comments that we received from the vendors.
So the conflict is between the Federal Register and New Hampshire law.
Well, I respectfully disagree in the sense that the violation, the fact that the device just says, okay, you're pretty close to being rung up with a violation, which could extend or suspend your driver's license, depending on how many violations you may have had in any period of time. And it's just going to delay your movement until your alcohol level comes down. While a 0.025 is you're going to be found in violation of the program.
Mr. Chair, just what are our options at this point?
There is a conditional approval request that has been submitted, so basically the committee could approve the final proposal, approve the conditional approval, or preliminarily object. And there would need to be a basis for the objection, such as legislative intent.
You could also postpone, and the committee, or I'm sorry, the department could come back with a amended conditional approval.
Yeah, they could come back with amended conditional approval. Just to go back to 265A37, Roman 3A, I mean, this statute, I did not find any place that said exactly what the device has to be set at. And the statute does state that upon satisfactory proof that a person who is restricted by law to drive only a motor vehicle equipped with an ignition interlock device has attempted to start a motor vehicle equipped with the device while having an alcohol concentration of 0.025, or who fails to retake the test. So it's talking about the penalties associated if they try to drive with that concentration. Didn't see anything again that states what the device must be set at.
Can I make a movement to postpone? Second. A motion to postpone, sorry.
We have a motion and a second to postpone. Discussion. All those in favor?
Aye.
Any opposed? Okay, you're postponed.
I just have to-
Passenger Tramway Safety Board, we don't have.
Correct. They have not submitted their
They have not
objection response yet.
Okay.
One other point, Mr. Chairman. On 3 of the HHS rules, well, 2 of them, there were conditional approvals, and 1 there was an amended conditional approval. The committee approved each of those. Just for the record, I wanted to make sure that the committee was approving the conditional approvals or amended conditional approvals.
Safe to say yes.
Thank you. Also, continued meeting.
We can dispense with the continued meeting.
And we have no other business for you.
Hmm.
We have nothing under other business.
Meeting is adjourned.